Ready, start. This means that the court master is required to record appearances in the record of proceedings only of (first senior advocate RAOR or advocate who is physically present and arguing in the court on behalf of a party at the time of hearing of the matter, and second, one advocate RAOR each for assistance in the court to such arguing senior advocate RAOR or advocate as the case may be. Full stop. Therefore, along with the arguing senior advocate RAOR or advocate appearing for a party, further additional appearance of only one advocate RAOR as the case may be, who is assisting in the matter, could be recorded. Full stop. Of course, any subsequent change in the engagement of the AOR or the senior advocate or the arguing advocate by the party, may be intimated by the concerned AOR by submitting an appearance slip afresh to the concerned court master, and the concerned court master shall have to mark the appearances of the advocates accordingly in the record of proceedings. Full stop. It is difficult to accept the submission made on behalf of the applicants' associations that it has been the practice in the Supreme Court to get appearances of all counsels marked, who are present in the court for a particular case, and contributed or assisted the arguing counsel. Full stop. It hardly needs to be stated that no practice could be permitted to overrule the statutory rules, particularly when the rules are framed by the Supreme Court in exercise of the powers conferred under Article 145 of the Constitution. Full stop. The said rules having a statutory force have to be strictly adhered to and followed by all concerned, that is, by the officers of the court, including the court masters as also the advocates. Full stop. There has to be effective participation or assistance by the concerned advocate assisting the arguing advocate in the case, when the matter is being conducted in the court. Full stop. Casual, formal or ineffective presence in the court along with the AOR or arguing advocate, without due authorization by the party concerned, cannot entitle the advocate to insist the court master to record his or her appearance in the record of proceedings. Full stop. The submission that the impugned directions given by the court would have an adverse impact on the rights of the advocates to vote, to be considered for the allotment of chambers in Supreme Court premises and for the designation as senior advocate, also has no force. Full stop. In this regard, it may be noted that the issues with regard to allotment of chambers in the Supreme Court premises and about the voting rights of the advocates in the elections of Supreme Court Bar Association have been raised and considered by this court in various judgments. Full stop. In Gopal Jha case Supra this court had reiterated that there is no fundamental right or statutory right of an advocate to have an allotment of chamber in any court premises, and that it is only a facility which is provided in the court premises. Full stop. It has been further observed that the members of SCAORA or other similarly situated persons who are members of SCBA can make only a request to the Chambers Committee constituted under the Supreme Court Lawyers' Chambers allotment and occupancy rules framed by the Supreme Court on administrative side, for the allotment of chambers within the compound of Supreme Court. Full stop. The said rules govern the procedure and the eligibility criteria for allotment of chambers, which are binding to all. Full stop. The issues with regard to the voting right and the right to contest elections of SCBA, have also been crystallized by this court in Supreme Court Bar Association and others (supra), in which it has been held inter alia that right to vote or to contest Election is neither a fundamental right nor a common law right, but is purely a statutory right governed by the statutes slash rules slash regulations. Full stop. We therefore need not elaborate any further on the issues raised, except to observe that members of the applicants dash associations are bound by the rules and regulations with regard to right to the allotment of chambers and with regard to the right to vote or right to contest elections of the bar association, as also they are bound by the Supreme Court rules, 2013, framed under Article 145 of the Constitution of India. Full stop. In the aforesaid premises, we are of the opinion that the said Supreme Court rules, 2013, as amended by rules, 2019, having the statutory force, have to be adhered to and complied with by all the officers of the court as also the advocates practicing in the Supreme Court. Full stop. The Supreme Court being the highest court of the country, the practice and procedure being followed in the Supreme Court proceedings by the advocates and officers of the Supreme Court have to be strictly in accordance with the statutory rules framed by it, and not divorce the said rules. Full stop. Subject to the above modification in the directions contained in para 42 of the judgment dated 29/2024, the miscellaneous applications stand disposed of. Full stop.